In this exchange, Representative Scanlon directly challenges FBI Director Kash Patel over the unresolved questions surrounding the Epstein investigation. While Patel repeatedly claims the Bureau follows the money, new reporting suggests over $1.5 billion in suspicious bank transactions tied to Epstein and possible co-conspirators. What follows is a tense back and forth about accountability, transparency, and why so many financial trails appear to remain untouched.
I am concerned by your repeated claims that you're not able to disclose anything further about the Epstein investigation and files, and that there's no evidence of a broader conspiracy or other people who should be charged, because the American people aren't buying that you've been transparent or that there's nothing further to be seen. In your exchange with my colleague, Mr. Roy, you reiterated something that I heard you say yesterday in your Senate testimony, and that is, under your direction, the FBI will always follow the money. Is that right?
The money, did you say? Yes.
Yes, you said you'll follow the money. That's great. And just now you said you welcome the opportunity to investigate new evidence. So there has been significant recent reporting just in the last couple of weeks that after Jeffrey Epstein was arrested, 4 major banks flagged more than $1.5 billion in suspicious transactions connected to him that suggested a massive conspiracy related to his child sex trafficking activities. Director Patel, has the FBI reviewed the $1.5 billion in suspicious bank transactions flagged to the government relating to Epstein and his co-conspirators?
I know the FBI has reviewed numerous SARs. I don't know the totality of that number.
Okay, can you provide us with that number?
I'll get back to you.
Okay. And have you initiated any new investigation of those bank transactions since, say, September 8th, when the new reporting came out?
I'll check with the Treasury Department because they're the lead on that.
Okay, so Director Patel, how many individuals or entities has the FBI interviewed, subpoenaed, or compelled to testify? Can you give us those numbers with respect to these bank transactions?
Not off the top of my head. I'll have to work with Treasury.
Okay. We're concerned, you see, because you say you're going after child predators, but obviously this is how you follow the money, is if you follow the bank transactions that apparently enabled the child sex trafficking. Would you agree?
It's one of the valuable investigative tools is to follow the money.
Okay. Have Jeffrey Epstein's victims have asked us to ask you whether or not you've investigated Epstein's lawyers, the lawyers who facilitated those payments. Have you subpoenaed or questioned any of those lawyers?
So in 2018 and 19, what I recollect is many, if not every one of those lawyers was part of the investigation.
But you weren't there at that time, right?
I wasn't there.
Okay. So can you get us the names and the numbers of who was investigated then with respect to those lawyers?
As long as I'm allowed to release it, absolutely.
Okay. Well, if we provide you with subpoenas, I assume you can release it. Is that right?
We have a current subpoena and we're working with Congress to provide it.
Okay. You've said that the Acosta investigation had an original sin. What do you mean by that?
Basically, if you're looking at an actual pedophile ring, what you should not do is limit the time frame in which you are legally able to collect information. So search warrants that Mr. Acosta utilized in 2006 and 7 leading to the 2008 plea agreement had a very specific narrow window of years, I think 3 or 4 years. And so information pursuant to legal process wasn't collected for 10 years or 15 years or 20 years. It also, subpoenas were not sent out to hundreds of witnesses at the time, hundreds of victims at the time. None of that was done. None of these people were put in grand juries. And so the totality of information from the jump, instead of being this big, was like this. And that, in my opinion, is not how you run an investigation if you're trying to break a sex trafficking ring.
So you're now in charge of the FBI. Why haven't you done that investigation?
Great question, and here's the answer. Simply because I am not able to go back 20 years and collect information that the courts had decided was already subject to search warrants. They have said, this was in the investigation, there's a non-prosecution agreement out of that plea, and when the case was reopened, and this is where it comes into play, when the case was reopened in 2018 and 2019, the search warrants, again, were limited to the conduct of Jeffrey Epstein. Now, whether that's right or wrong, that's a different discussion, but I'm telling you, that's the
Okay,
information
well,
we
I think that
reviewed.
is a different discussion, and I think the discussion we'd like to have today is why you aren't following the money with respect to the broader conspiracy that it has been reported in the New York Times and elsewhere, and that if you really want to attack the issue, if you wanted to attack the issue, if you wanted to get to the bottom of it, if you wanted to disclose what really was involved in the Epstein files, the Epstein cover-up, that you would be taking very different actions that you are today. I do want to seek unanimous consent to enter into the record the New York Times September 8th, 2025 article, How J.P. Morgan Enabled the Crimes of Jeffrey Epstein,
Objection.
and also an article dated July 17th, 2025 in the Epstein case, Follow the Money.
Objection.
Okay.
The concern raised in this exchange reflects a deeper and unresolved problem surrounding the Epstein investigation: the persistent mismatch between official assurances and verifiable investigative action. The question being asked is not whether the FBI has spoken about transparency, but whether its conduct matches those promises. When Director Kash Patel reiterates that under his leadership the Bureau will follow the money, he is invoking one of the most basic and effective tools in criminal investigations. What follows, however, suggests that this principle has not been meaningfully applied to the most consequential financial evidence connected to the case. Recent reporting that more than $1.5 billion in suspicious bank transactions were flagged after Epstein's arrest is not marginal or speculative information. These are transactions identified by major financial institutions and reported to the government precisely because they suggest criminal activity. Yet, when asked whether the FBI reviewed the full scope of this data, Patel cannot provide a number. When asked whether new investigations were launched in response, he defers responsibility to the Treasury Department. When pressed for how many individuals or entities were interviewed or subpoenaed, the answer again is uncertainty. This matters because following the money is not an abstract commitment. It produces records, targets, timelines, and accountability. Financial trails reveal who enabled crimes, who benefited from them, and who looked the other way. A law enforcement agency claiming to prioritize child trafficking cases should be able to clearly articulate what it has done with evidence of this magnitude. The inability to do so naturally fuels public skepticism. The discussion surrounding Epstein's lawyers deepens those concerns. Victims have specifically asked whether attorneys who facilitated payments were ever scrutinized. Patel suggests that many or most were investigated years ago, but he cannot identify who, how thoroughly, or with what outcome, and he acknowledges he was not in charge at the time. Without transparency, such assurances function more as deflection than accountability. Patel's explanation of the original sin of the Acosta-era investigation is detailed and largely accurate. Narrow warrants, limited timelines, and the 2008 non-prosecution agreement severely restricted the collection of evidence and prevented a full understanding of the trafficking network. But this explanation also underscores the central question. If those failures are known, why have they not been meaningfully addressed since? His response is essentially that the courts have closed the door. Prior warrants were limited, later investigations focused only on Epstein himself, and the legal framework prevents revisiting broader conduct. That may be a defensible legal position, but it does little to restore confidence. Laws do not prohibit investigating new evidence, new financial data, or institutional enablers when credible reporting emerges, especially when that reporting points to systemic failures within major banks. The objection to entering investigative journalism into the official record only reinforces the impression that institutional caution has replaced investigative urgency. For the public, this exchange confirms a long-standing suspicion. The Epstein case did not end because all truths were uncovered, but because pursuing them further became uncomfortable. Ultimately, this hearing is not about revisiting the past for its own sake. It is about whether justice is willing to confront powerful interests when the evidence leads there. When the FBI cannot clearly explain how it has handled billions of dollars in suspicious transactions tied to child sex trafficking, reassurances alone are no longer enough.